Thank you, Madam Deputy President. I rise to speak on behalf of the opposition on the Local Court and Bail Legislation Amendment Bill. And I note that we have just been discussing the Justice Legislation Amendment Miscellaneous Bill. A relatively slight offering, but doing a lot of heavy lifting if you look at what this bill actually did. It made changes to the number of people serving on advisory boards for the children and young people. It made significant changes to a highly contentious section, Section 93Z of the Crimes Act. It made significant changes to the Birth, Deaths and Marriages Act. It made a number of changes in relation to children in detention. It made significant changes to the Firearms Act. And I'm only about a third of the way through what this slight bill did. And now we come to this heavy tome. 50, 60 pages of the Local Court and Bail Legislation Amendment Bill. Now, I say at the outset that we're happy to support these changes, although there aren't that many changes to support, despite the vast number of changes. What does this bill do? We know that what it does is change the name of magistrates to judges, and entirely agree with the government that the work that our magistrates do in the local courts is growing in complexity, is growing in volume, is really important work. The local court is the first point of contact that a number of people have with the justice system. It dispenses justice to a high volume of matters. It is a very important court, and magistrates work very hard and do work that deserves our utmost respect. And to the extent that this is recognised by changing their title, then we have no objection to offering them respect. But I would observe that this will do nothing to address the workload in the local court. It will do nothing to address court delays. It will do nothing to lift the growing burdens on our local court magistrates. And so you wonder why this is being done at all, if this is token respect rather than actual respect. What's in a name? No change at all unless there are additional supports and resources available to magistrates to deal with complexity and workload. We know that not all local courts have AVL links, which are now necessary if the new bail division is to function properly. This matter isn't addressed by this bill. We know that the newly minted local court judges have less in the way of support staff, less in the way of research staff, less in the way of support from tipstaves and other officers than judges of the District Court or the Supreme Court have. Support that could facilitate the enormous volume of work that they have. This is not being addressed by this bill. It is, we know, and the bail division has really exposed this as a major issue, that there is support needed so that the local court can digitise its records to make the proceedings of the bail division more effective and more efficient. This isn't addressed by this bill. So it is hard to see this bill as anything but lip service. And frankly, our magistrates deserve more. They deserve real respect. They deserve real support to cope with the increasing workload, rather than just a new title and the opportunity to get new stationery printed. We do not oppose it, but we are very disappointed that it is merely a change of title. It is not helping police and the courts who are dealing with repeat youth offenders. It will not ease the frustration of victims who are facing enormous court delays, because this court is stretched right to capacity, if not beyond. And frankly, we expect more from the government than symbolic gestures. We expect actual thought about the way our court system works. We expect real respect for judges. For example, the sort of respect that may have meant that before judicial pays were frozen, somebody might have told the judges. That would have been a sign of real respect, not accorded by this government to any judicial officers, including our newly minted local court judges. And I want to thank those local court judges. I want to thank them for the really difficult job they do every day. With a caseload that is up 34% in the last decade, 34%. But the title change alone will not change the pressure that they are facing. The other change that is made is a really curious change. In fact, I note that it's been described as minor technical amendments that will just make sure that registrars aren't making bail decisions. I say that that's curious because when 70A was first introduced, my colleague in the other place, the Honourable Alistair Henskins, had an amendment. And he said, you know what, let's make this amendment to make sure that registrars will no longer be making bail decisions. They'll all be done by judges. And the Attorney-General said, not needed. We don't need this legislation change. We'll do it all by administrative changes. And what have we got now? We've got a raft of changes. Now, either these changes are totally unnecessary or the Attorney-General got it wrong at that time. Which is it? And it is very disappointing that at the time when Parliament was invited to, by my colleague, the Honourable Alistair Henskins, the appropriate amendments weren't made. So we're not opposing anything in this weighty bill, but we are disappointed. We are disappointed that the bail changes weren't made in a timely fashion, and we are disappointed that all this offers to the newly minted judges of the local court is lip service rather than the real resourcing and the real respect that the very hard work that they do actually deserves.